Property division, the house and everything in it. Dustin McCrary, divorce attorney and founder of the law office of Dustin McCrary, discussed the basics of the process of property division during a divorce. Hi, I'm Dustin McCrary. Thanks for joining me today. Today, I'd like to give you an overview of one of the most important issues that couples will face during a divorce: property division. Of all the issues that couples encounter during a divorce, aside from issues regarding their children, property division issues can be some of the most emotional and complex. After all, for many people, property is more than just stuff. Many of us often associate our belongings with memories. Certainly, this is true of the family home, where most of the family memories are likely made, but it can also be true with respect to many other things: the family car, the pets, special souvenirs from trips, family heirlooms, and many other items. Before I discuss the nuts and bolts of property division, it's important to tell you that, as with every other issue in a divorce, ultimately you're going to be the best judge of what's ideal for your family. If you and your spouse are able to work together cooperatively toward coming to an agreement, that's the best of all possible options. Doing so gives you the freedom to truly sit down and look at your assets and debts and decide what division would work best for your family's lifestyle. For example, you may be able to sit down and look at one spouse's work schedule and travel demands and decide fairly easily that it's best for the other spouse to stay in the marital home. Once you've made that decision, you can then move forward with allocating other pieces of property to the spouse that will move out of the home to make the situation fair and agreeable to everyone. In other situations, you may decide for one spouse to buy out the other spouse's interest in the home. This is an option that many couples choose, and while it can be complex initially, it's often worth it in the long run. Ultimately, choosing to divide your property by agreement truly gives you the freedom to make whatever allocation of property works best for you. In some situations, however, for any number of reasons, cooperative negotiations between spouses is simply not possible during divorce. In this case, the matter will be left up to a court to decide. In North Carolina, it's important to understand that courts will divide property according to a theory of equitable distribution. Often, people hear the word equitable and assume that it means equal. It's important to realize that this is not necessarily so. Instead, what a court will do is look at a couple's entire financial picture, assets and debts included, and then a court will seek to divide the property in the most fair way possible. This does not necessarily mean equal split 50-50 down the middle. It simply means that the court will seek an even-handed balance overall. As a court seeks to divide your property, it will first look at whether your property is marital, separate, or divisible. Marital property is essentially property which the parties acquired together during the marriage. This will be the category that most of your property falls into. Separate property, however, is property that belonged to one spouse prior to the marriage or was given only to one spouse. Your attorney will be able to advise you more specifically as to what constitutes separate property, but it's generally property that one spouse either owned before the marriage and kept separately throughout the marriage, or that was gifted to a spouse through either an inheritance or some other request that specifically indicated it was for that spouse only. If you can establish that property belongs only to you, it likely will not be divided by the court in a property division process. Finally, there's also divisible property. Divisible property is property that was acquired after the date of separation and the date the property was divided, or it might include any appreciation or depreciation of marital property. Typically, for the most part, however, most property will be classified as marital or separate. As a court makes its decision on property distribution, it's going to try to trace the property back to make a final determination as to whether it was marital, separate, or divisible property. After doing so, the court will have a list of 13 statutory factors that it can consider as it determines how to distribute the property. Some of those factors include the health and welfare of the parties, the education of the parties, whether one spouse got a degree during the marriage or began working a high-paying job while the other spouse stayed home, and any number of other factors. In the end, though, the goal is generally a distribution that is as fair as possible. One thing to keep in mind if you choose to allow court to make the decision for you, however, is that this is exactly what will be happening. When you leave the matter to a court, you are relinquishing your control over the outcome. As a result, it's important to think very carefully about whether or not you truly want to do this. In some cases, it's the only option. But in many cases, couples leave the matter up to a court, only to find out in the end that the distribution is not ideal for their family. At that point, you're left with fewer options other than filing an appeal or trying to get your ex-spouse to agree to something different. Ultimately, regardless of whether you choose to divide your property by agreement or if you choose to leave it to the court, you should keep in mind that property means far more than tangible items. Certainly, it means your marital home, but it also means things like bank accounts, retirement accounts, pension plans, investment accounts, credit card debt, car loans, and anything else you can think of. Think over all of these items carefully with an eye toward what would truly be best for your family. It can also be helpful as you begin the process of considering property division to begin collecting important documentation that reflects your assets, debts, and all of the property you own or hold title to. Things like tax returns, financial statements, insurance policies, deeds, titles, investment account statements, bank statements, information about retirement accounts, and more. Gathering all of these items and storing them in a safe place will be important. You don't want to overlook these administrative sorts of tasks. They'll save you a great deal of headache in the long run. In the end, as with almost all issues in a divorce, property division is not something that you want to approach on your own. Even if you feel that you have a comprehensive understanding of your financial picture, there could be legal loopholes and nuances that you don't understand that could end up becoming quite costly down the road if they're overlooked. Having the assistance of a knowledgeable and experienced attorney can go a long way, not only toward giving you peace of mind, it can also save you money and avoid a great deal of headache in the long run. Thanks for joining me today. I know that this is a lot of information, and at the beginning of any legal process, issues can seem complex and overwhelming. The good news is that they don't have to be. Having the right attorney on your side, one with knowledge and experience, and the commitment to pursuing the best strategies on your behalf can make a world of difference in the peace of mind and level of preparedness you feel about the process. If you're ready to begin the divorce process, or if you find yourself in the midst of the process but need excellent and effective representation, I'm here for you. I encourage you not only to look through this site for helpful and valuable resources, but also to get in touch with me so that we can discuss your case. I look forward to helping you soon.